How to stop wage garnishment in Georgia. A creditor has won a judgment against you, and now money is being taken from your bank account or your paycheck to satisfy an old debt. If you found yourself in this situation, you may consider it a financial emergency. Losing as much as 25% from each paycheck can put quite a strain on your finances. However, if you live in Georgia, you have several methods at your disposal to possibly stop the garnishment. Method 1: Filing a traverse and claim against the garnishment. 1. Find out when the garnishment occurred. Georgia law only gives you a limited period of time to stop a garnishment using a traverse and claim. When a creditor files a garnishment lawsuit with the court, it essentially sues your bank for the money. The bank will be served with notice of the garnishment. After the bank is served, it has between 30 and 45 days to file an answer with the court. From the date the bank files its answer, you have 15 days to file your traverse and claim against the garnishment. To know how long you have to file your traverse and claim, you must find out when your bank was served or when it filed its answer. Since you probably will not receive notice of the garnishment action until funds are removed from your account, you probably do not have much time to act. 2. Download the appropriate forms. Georgia courts or legal aid offices have standardized forms you can use to file a traverse and claim against the garnishment. Read carefully the information and instructions that come with the forms, so you are certain the possible exemptions apply to you before you proceed. Some sources of income, such as Social Security benefits and certain pensions, cannot be garnished. If you receive income from any of these sources, you are entitled to have your money returned to you. However, you must first request the money be returned to you through the court. If you show the court that your money cannot be garnished, the court will order the creditor to return those funds to you. 3. Gather information to support your claim. Since you can only file a traverse and claim for certain legal reasons, you must review your situation and the law to see if one of the exceptions applies to you. When a creditor gets a judgment against you, it files an affidavit with the court to get a garnishment of funds in your bank account. As part of this affidavit, the creditor states that it has the ability to garnish those funds. However, if your income is exempt, it does not have this ability. A traverse is a legal document in which you state that information in the creditor's affidavit was false. You then file a claim which lists the reasons you are entitled to have the garnished money returned to you. If all or part of your income comes from an exempt source, pull together documents such as bank account statements or Social Security benefit statements that support your argument. For a checking account, you typically will need statements showing deposits that go back 3 months. For savings accounts, you might need statements going back a longer period of time, especially if deposits were made less frequently. Wages are only partially protected depending on how much money you've made. If your wages are directly deposited from your employer, however, you have an easier time showing which amounts in your account came from wages, and which came from other sources. If your account is a joint account, Georgia state law divides the money in proportion to the money each account holder put into the account. Therefore, if the garnishment came from a joint account, you must provide the appropriate documentation to prove which money is yours and which belongs to the other account holder. For example, if you have a joint account with your spouse, and your spouse deposits 75% of the money in the account, while you deposit only 25%, the creditor only has the power to garnish a maximum of 25% of the money in the account, subject to any other exemptions. 4. Complete your forms. Once you've determined the appropriate justification for your traverse and claim, fill in your information. When a creditor garnishes money in your bank account, the only entities who are parties to the garnishment suit are the creditor and your bank. The traverse and claim essentially allow you to intervene in that garnishment lawsuit and claim you have a superior right to the money the creditor garnished. Next to each exemption you state applies to your money, you should include a citation to the state or federal law that exempts that money from garnishment. If you have difficulty finding this information, an attorney or someone in the legal aid office may be able to assist you. 5. Make copies of your paperwork. After you've filled out the paperwork for your traverse and claim, you must make 3 copies. One of those copies is for your own records, the other 2 are for the creditor and your bank, the 2 original parties in the garnishment lawsuit. The clerk of court will keep the originals when you file them. 6. File your forms with the appropriate clerk's office. You must file your forms with the clerk's office where the original garnishment judgment was entered. You must complete and file a cover letter along with your traverse and claim, and pay a filing fee. The filing fee for a traverse and claim varies among counties, but usually will be less than $50. You also must have your traverse and claim served on the creditor and the bank that were the original parties to the garnishment lawsuit. Typically you would use the sheriff's office to have the parties served. You must pay a fee for service of process. 7. Attend your hearing. If the judge orders a hearing on your traverse and claim, you must appear in court or the judge may dismiss your claim. Arrive to the courthouse at least a half hour early so you have time to go through security and find your courtroom. Bring along with you copies of all the documents you filed as well as any other documents or witnesses that support your claim. Method 2. Settling the debt. 1. Contact the original creditor. Typically you can find contact information on the original judgment form at the clerk's office. Under Georgia law, creditors usually can only garnish up to 25% from your paycheck. However, you may not be able to pay your bills on only 75% of your pay. If you have money saved up, you might consider using some of your savings to pay off your debt. You might consider having a bankruptcy attorney contract the creditor. If the creditor hears from a bankruptcy attorney's office, they may believe that you intend to file for bankruptcy, in which case they would get no money at all. This prospect can make the creditor more willing to work with you. 2. Negotiate a settlement. If you have the ability to pay, the creditor may be willing to take substantially less money than you owe to settle the debt. You typically will have better luck negotiating a settlement if you contact the creditor through an attorney. Although you may believe you don't have the money to pay for an attorney's fees, it could be worth it if the attorney is able to get the creditor to settle for a fraction of the amount you owe. Creditors typically will want a lump sum payment to settle your debt. After having gone through the effort to get a judgment against you, they often aren't willing to set up a payment plan with you, especially since they have no guarantee that you'll keep up with the payments. In some situations, you may be able to get a stipulated judgment through the court. This would mean that you would pay the debt through the court rather than having the money garnished from your paycheck, which would allow you to plan smaller payments. Talk to an attorney or someone in the legal aid office to learn more about your options. 3. Get the agreement in writing. Once you and the creditor reach an agreement, make sure you get the agreement in writing, including any promise to dismiss the garnishment. 4. Follow up to make sure the garnishment is dismissed. After you've paid the creditor, make sure no more money is taken out of your paycheck. Since you have a judgment against you, get a satisfaction of judgment signed by the creditor and filed with the court, and follow up with your credit reports to make sure the judgment is removed. Method 3. Filing for bankruptcy. 1. Review the bankruptcy forms. Download a bankruptcy form and read through it before you proceed so you have a good idea of the information and documents you will need. Bankruptcy is a legal process through the federal bankruptcy courts that allows you to eliminate some of your debts, or pay them back with court supervision and protection. Bankruptcy is the easiest way to stop wage garnishment, because once you file for bankruptcy the court places an automatic stay on any garnishments, and the creditor can no longer collect on the judgment that way. However, in many cases you won't be able to get back the money that was already garnished. You may be able to recover amounts transferred to the creditor within 90 days of the date you filed bankruptcy. 2. Consider consulting an attorney. Because bankruptcy law is complex and you have a lot at stake, it is in your best interest to work with an attorney. If you file your petition without legal assistance and make a mistake because you don't know the law, you can lose your property. For example, you could lose your house because you didn't know it could be exempted under the federal bankruptcy law. Additionally, if you make a mistake in filing bankruptcy, your case could be dismissed and it could be more difficult for you to file again in the future. An experienced bankruptcy attorney can review your case and tell you whether filing for bankruptcy is right for you. Filing bankruptcy is a major decision that you probably shouldn't make solely for the purpose of stopping a single wage garnishment. There are other alternatives to filing for bankruptcy that can allow you to get a better handle on your financial situation. 3. Complete credit counseling. The state of Georgia requires you to complete credit counseling before you can file for bankruptcy. Your credit counseling must be completed within 6 months before you file for bankruptcy, with an agency approved by the U.S. trustee in your area. A list of approved credit counseling agencies in Georgia can be found at 4. gather the information you need to complete your petition. As part of your petition, you must file an in-depth list of your finances over the past 2 years. You also must include a number of documents including copies of your tax returns for the past 2 years, deeds to any real estate you own, car titles, and agreements for any loans you might have. Required documentation also includes a list of all property you own, including personal property, and a list of all of your living expenses. 5. File your petition and other required forms. Once you've completed all the necessary paperwork, you must file it at the correct Georgia District Bankruptcy Court. Georgia has 3 federal judicial districts: the Northern District, the Middle District, and the Southern District. The correct district is the one where you have been living for the majority of the 180-day period before you file, or the district where you have a residence, if you've been living somewhere else such as a military base temporarily. Along with your 2-page petition, you also must file a number of schedules that describe your current financial status and financial transactions within the past 2 years. When you file your petition, you must pay a filing fee of around $300, depending on the type of bankruptcy you file. You cannot apply to have this fee waived, although you may be able to pay it in installments. Once you file your petition, an automatic stay is entered immediately, which prevents creditors from contacting you in any way and stops all garnishments or foreclosures. 6. Proceed with your bankruptcy case. Keep up with each step of your bankruptcy case to ensure that the stay isn't lifted on the garnishment. After filing your petition, you also must complete additional debtor counseling before your debts are finally discharged.